Hi everyone, it's Antonia Mercorella, CEO of the REIQ, coming to you live today from the REIQ Property Management Conference. Yesterday, on the 21st of March 2024, we saw the Minister for Housing introduce a new bill into Parliament. The Residential Tenancies and Rooming Accommodation and Other Legislation Bill. And of course, this bill does a number of things, but in particular, what I want to talk about today is that it introduces Stage 2 rental law reforms, and I'd like to take you through a summary of that. But also, significantly, it also creates the pathway for the introduction of continuing professional development training for all real estate professionals in Queensland. So I want to start with the good news, which is the introduction of CPD for the real estate community here in Queensland. Many of you will know that the REIQ, as the peak body, has been advocating for the introduction of CPD here in Queensland. It does exist in other jurisdictions, and of course, we want this because we want to ensure that we are continuing to raise the standards for real estate practitioners in Queensland. And we know that many of you have said to us that you want to feel proud of the profession that you belong to. And I think that we can all agree that the role that a real estate professional plays in our community is incredibly important. Real estate practitioners are involved in the sale and management of what is, for most of us, our most significant and valuable asset. And so we think it stands to reason that on a regular basis you are required to keep your training up to date. And it really is important from a consumer protection perspective, but I think it also means that we will see only those who are very serious about their profession staying in the real estate community. So certainly we think it's a momentous occasion, and we thank all of you who have been supporters behind that. You'll be able to find out more about CPD in our position statement, which is available in the member resources area, but I'll say more about that at the end of today's video. Now, of course, many of you are waiting with bated breath to hear about what Stage 2 rental reforms look like. So I wanted to take you through a fairly high-level summary in this video, but again, the team at the REIQ has done a spectacular job of summarising that bill in great detail. It only went into Parliament yesterday, so we've literally been working around the clock to put that resource together for you. But today, I'll give you an overview, and again, then I'll direct you to where you can go to get much more detailed information. So let's have a look at a summary of what's coming in terms of Stage 2 rental law reforms. So first of all, let's start with alterations to property or modifications. This is, it's fair to say, a fairly controversial topic. So the first thing that the bill does is it creates what's called a head of power. And so this really means that if and when the bill is passed, it will create a power in the Act, in the Residential Tenancies and Rooming Accommodation Act, but it will then create a way that that head of power can be relied on to actually create further legislative change in the regulation, much the same way that we saw the minimum housing standards create a head of power. And so what that will mean is that there will be a head of power created for modifications that relate specifically to safety, security, or accessibility. So this is where a modification request is asked for on one of those grounds. So the bill says very little about how it will work in operation. It really just, as I say, introduces a head of power with a view to actually legislating around that at a later date. However, what the bill does do is that it introduces a new process for tenants and lessors to deal with a request for a fixture to be attached to a rental property or for a structural alteration to be made to the property. And the way that this new process works in summary is that the tenant will be required to ask for that in using an approved form. So there will be a standard template form that needs to be used, and then the lessor will be required to respond to that request within a set statutory time frame of 28 days from receipt of that request. And ultimately, the lessor can then agree or not agree, but of course, the lessor will not be able to unreasonably withhold consent. In the event that the lessor does say yes to the tenant's request, they can impose conditions in relation to that request. So again, I'm sure that will make a number of you listening very nervous. I'm not going to say too much about what our position is in relation to these things, because I'll direct you to that at the end of the video. For today, I want to focus on giving you the summary, but we do want your feedback on these things. So the second item, which of course has received a huge amount of press attention, is the topic of changes to rent. So let's start with rent bidding and rent in advance. Now, you've heard both the Premier and the Housing Minister talking a lot about outlawing rent bidding. And of course, those of us in the know are aware that rent bidding is already unlawful in Queensland. That is already law today. We know that when we advertise a property for rent, we need to do so with a set price, and we can't call or ask for an amount above the asking price. However, what the bill does do is that it no longer allows a tenant to offer a greater amount of rent. Well, that's not quite true. Let me rephrase that. A tenant can offer more than the asking price, but of course a property owner or a property manager can't accept a price that is above the advertised price. Now, again, I know that the reason that that is happening is that it's very much a symptom of the tight market we're seeing, and because it's so competitive, but it is important to understand that you will not be allowed to accept more if and when this becomes law. And just staying on that theme, we also know that we have been seeing tenants offering rent in advance. Again, if and when this becomes law, you will not be allowed to accept rent in advance that is greater than the statutory limit, and that will be set at 4 weeks is what's being proposed. So even if a tenant volunteers to give you 6 months in advance or 12 months in advance or 3 months in advance, you won't be allowed to accept anything greater than the amount that is permitted under the new laws. Now, of course, still staying with the topic of rent, as we all know, last year we saw new legislative amendments which restrict the amount of times you can increase the rent to once every 12 months. Now, that is already law today. That law started on the 1st of July, but many of you will remember the disastrous consequences that followed because of the very sloppy implementation of those new laws. Now, what's really concerning to us is, instead of leaving that as is, because it's established law now that we can only increase rent once every 12 months, the Miles government have gone a step further, and we say it's a very dangerous and quite a radical departure from established tenancy law, and that is that 12-month limitation, instead of attaching to the tenancy agreement, will attach to the property itself. Now, the Minister has touted this as some sort of a fixing of a loophole, and quite frankly, all it is trying to somehow cover up again poorly implemented legislation. So what we're concerned about is that we now have a situation, potentially if this passes, where a limitation that is imposed in rental legislation is then somehow attaching to the property, almost like an encumbrance. And then when that property is sold, it will mean that those obligations continue with that property. Now, you can imagine the impractical consequences of that. we're going to have a situation where somehow the current owner of that property needs to sell the property and give that information to the new owner. It will also mean that if the new owner comes in, they will also be bound by that 12-month restriction as well. So we think it's going to create some impracticalities. And of course, the example that we're also citing is that the new owner may come in and do quite extensive renovations, or some renovations add value to the property, and they will still be bound by that 12-month rule. If they do want to charge more rent than what was charged by the previous owner, they'll have to go to QCAT to be able to prove that they should be allowed to ask for higher rent. But in order to do so, they will have to show that they will otherwise suffer undue hardship. And QCAT, when determining that matter, will also have to take into account the tenant's circumstances. So you can only imagine how impractical that will be, given how busy QCAT already is and what waiting timeframes already look like. Now, the other important thing to note is that tenants will have the ability under these new laws to request a copy of the last tenancy agreement that relates to that property, and they'll be allowed to actually ask for a copy of the tenancy agreement, but of course, and you'll be required to provide that. And of course, you will need to remove the personal information about the tenant. So that one's going to be a very tricky one to navigate. And then finally, on the issue of rent, we've also seen the Minister for Housing saying that this bill introduces a requirement to offer a tenant at least one fee-free method of rent payment. This one's got us a little bit stumped, because as far as we're concerned, the Act already requires that, but it is in the bill, so we'll wait to find out more on that one. All right, let's move on now to bonds. What we've seen here is that when it comes to the return of a bond, what the bill is proposing is that you will need to substantiate any kind of a claim you are making on the bond within a set time frame of 14 days. So when you get to the end of the bond, if you wish to claim some of the bond on account of some sort of broken item, or to conduct a repair, or perhaps unpaid rent, etc., you will need to substantiate and provide evidence within 14 days of making that claim. And of course, the challenge with that one is going to be that in some instances, particularly in this current environment, it's going to be very tricky to get tradespeople and contractors to give you the quote on that. So we accept that bonds should be returned as quickly as possible. But again, we're concerned with the imposition of this blanket statutory time frame. So let's move on also, while we're on the topic of bonds, to this topic of the portable bond that we've heard the Premier and Minister for Housing talking about. Now again, we have seen a number of other jurisdictions talking about a similar concept. It remains to be seen as to exactly how on earth this is going to be implemented in practice. Again, what we see here is the establishment of, at this stage, only a head of power, with legislative amendments to be made down the track. And we also understand that a portable bond scheme will only be in existence for 2 years. So again, whether that actually ever sees the light of day and actually happens remains to be seen. Let's move on to fees now. So in the area of fees, when it comes to issuing a bill or an account of some kind, so this might be for water services, for example, or some sort of a utility bill, you will need to provide that to the tenant within 4 weeks of the owner receiving it. If you fail to pass that on within that 4-week statutory time frame, then the tenant will have no obligation to pay it. And of course, one of the more controversial changes in the bill, or proposed changes in the bill, is the introduction of a set. That doesn't quite make sense. Let me start that again. A formula for setting reletting costs in a break lease scenario. So at the moment, when a tenant breaks the lease and says they want to leave earlier, of course, the Act talks about the owner being entitled to certain compensation. The way that this will work is that the relet fees will be capped, and it will be capped based on a tiered system that will change depending on the number of weeks or months left on the tenancy. And again, there's more detail about that in the document that I'll direct you to at the end of this video. Let's move on to entry grounds. The bill proposes a new entry ground, which I think is a good idea and something we've advocated for. You will be allowed to gain entry to the rental premises for smoke alarm compliance. We all know that smoke alarm compliance is incredibly important, and we've just seen another tragic house fire. So I think we all know how imperative smoke alarm safety is. So that's a new ground. There'll also be some new limitations on entry that apply when a notice to leave or a notice of intention to leave is given. More information in the document I'll direct you to, and also notice periods when you are seeking entry will be extended from 24 hours to 48 hours. Of course, the other major change is the proposed introduction of a code of conduct. Again, we've seen the Housing Minister and the Premier talking about this. You've heard me say before that we've been disappointed by the rhetoric and language around this. It's been very focused on stamping out dodgy property managers and unscrupulous practices. I am pleased to let you know that we have advocated to the Housing Minister and said that if we're going to create a code of conduct, that code of conduct needs to apply to all parties and stakeholders. So yes, property managers, but also tenants and also property owners. And I'm pleased to say that the Minister for Housing agrees that that code of conduct should apply to all of those parties. And I am also pleased that the Housing Minister has agreed to allow the REIQ to play an instrumental role in building and shaping that code of conduct for property managers. And of course, we will offer up our best practice guidelines for property managers, and that will form a really solid foundation towards that. And of course, in the area of privacy, we will see some changes as well. In particular, tenancy applications. So the way that this will work, if these new laws are passed, is that there will be an approved single form for an application for a rental property. So you will no longer be allowed to just make up your own application process. There will be a prescribed form that needs to be used. And of course, it follows that the type of information you will be allowed to ask for when a tenant applies for a rental property, that will also be prescribed. And again, we've made it clear that it's really important that we have a hand in that. We've explained to the government that as property managers, you have a legal obligation to your clients. There is due diligence requirements that of course need to be respected and satisfied. So again, we're hoping to have a big influence in terms of what that form looks like and what you're allowed to ask for, so that you can satisfy yourself that the tenant has the financial capacity to meet the obligations under the tenancy, and of course has a history of looking after properties well. And of course, there'll also be some changes in terms of the way that you go about collecting information from applicants and how quickly you will need to dispose of that information and how you will need to store it. Much of that will be familiar to you because, of course, it's covered already by privacy laws. But not all real estate agents are governed by privacy laws because of the $3 million threshold. So that's why we're seeing those changes. Now, I appreciate that that's a bit of a whirlwind through the bill. It's a lot of information, and I've gone at a pretty cracking pace, and it's also a very high-level summary. So what I'd like to now direct you and encourage you to do is to take a look at our position statements, where we take you through the CPD framework in greater detail, and in particular where we delve into these stage 2 rental reforms and we cover them in a very comprehensive way. I want to congratulate the amazing legal team at the REIQ. We've literally been working all night so that we could release that to you today. And you will find that in our member resources area. So please get your hands on it, start familiarising yourself with these proposed changes, take a look at what the REIQ's position is, and what we're asking you to do is give us feedback on these proposed reforms, because the bill has gone into Parliament, but it still needs to go through a certain legislative process. There will be a parliamentary committee inquiry process that we will be participating in. So we would love your feedback. Tell us why these changes will or will not work in practice, because as we all know, sometimes the law works on paper but doesn't work in the real world, and you really need to give us the information we need to help the government understand why or why not in response to these laws. So we always love your feedback. We will need it, however, pretty quickly by the 5th of April. So you can send your feedback to us at advocacy@reiq.com.au. And just finally, what I really want to say before we close is that everything I've talked about today is not yet law. Let's be really clear about this. It's a bill that's gone into Parliament. It has not yet passed. And even if it does pass, the majority of these changes will not start immediately. So make sure you keep following us for more information about the status of the bill and its progress. It's really important you stay informed on this particular topic. And as always, we encourage you to keep reading the information that we send you. It's never been more important to stay informed. I'd love you to share this video with all of the property managers that you know so that we can get the message out to as many property professionals as possible. So as always, thanks for tuning in. We appreciate your time. Have a great weekend. Stay safe, and we will see you next